Number 2.
And for the petitioners.
Hmm.
The offences punishable under section 417, 420,
376 first ಹೇಳಿ
376.
ಆಮೇಲೆ 417
Yes.
420 go on.
376.
Ah.
The petition number 2 and 3 are the parents of the petition number 1.
ಈಗ who are before the court?
All the accused.
All the
Yes, my lord.
respondent is not present.
ಇಲ್ವಲ್ಲ?
Served unrepresented.
Yes, madam.
Respondent. Served.
And the respondent.
Counsel ಇದ್ದಾರೆ.
Counsel is there.
ಇಲ್ಲ 3 times I have posted the matter, not appearing at all. Government, yes. False from. It was false, ಅಥವಾ engagement ಆಗಿದೆ. False ಇಲ್ಲಿಂದ ಆಗುತ್ತೆ. Promise. Engagement ಆಗಿದೆ ಅಲ್ಲ?
Engagement ಆಗಿದೆ.
ಯಾಕೆ ಮದುವೆ ಆಗಿಲ್ಲ?
Some dispute arose between the parties.
What dispute?
Between the petition number 1 and the respondent number 2.
What dispute arose?
Some personal disputes.
What personally?
And now respondent 2 already married, madam.
ಅದಕ್ಕೆ not represented.
Now marriage was solemnized between the one Mr. Trishal and respondent 2 on 1/5/2024. I'm producing a marriage invitation.
1/5/2024.
Yes, marriage invitation card as well as marriage photos.
Oh, she called you also. Right?
Not like that.
ಮತ್ತೆ invitation card ಎಲ್ಲಿ ಸಿಗ್ತೀನಿ? You are not invited for marriage.
Not invited.
Yes, the petitioner is before this court calling in question proceedings in SC 24 of 2023 registered for offences punishable under section 376, 417, 420, 506 and 109 of the IPC. The petitioner heard source. The petitioner, second respondent is the complainant. The petitioner, first petitioner accused number 1 and the second respondent are said to have had relationship. The second petitioner and second and third petitioners are the parents of the first. It is the case of the prosecution that the petitioner, first petition, accused number 1 and the complainant meet on Instagram,
Instagram.
meet on social media, i.e. Instagram. The complaint of the complainant is that the petitioner, first petitioner, sends a request, friend request on December 9th, 2021, and then the friendship between the two began. The friendship flowers into relationship and the relationship into physical relationship for about 3 years. The relationship was taken further by the accused number 1 in talks of marriage, and a betrothal ceremony was also held between the for the accused number 1 and the complainant. The marriage did not take place. The breaking of the marriage after the betrothal ceremony is termed to be an offense under section 376 of the IPC, and a complaint is registered. The complaint then becomes a crime in crime number so and so. Crime number so and so. The police conduct crime number 81 of 2022. The police conduct investigation and file a charge sheet. Since the offense was the one punishable under section 376, the matter is committed to the Court of Session and is pending before the concerned court in SC 24 of 2023. The filing of the charge sheet is what has driven the petitioner to this court in the subject petition. The learned counsel appearing for the petitioner submits that the acts between the petitioner and the respondent for close to 3 years were all consensual. It was not on false promise of marriage, but was on promise of marriage, as all efforts for getting married to the complainant of the accused number 1 failed due to certain misunderstanding between the accused number 1 and the complainant, or the parents of the accused number 1 and the complainant. This is now termed to be a rape and cheating. The learned counsel would submit that the consensual acts between the two cannot be termed to be a rape, and breach of a genuine breach of a marriage cannot be termed to be a false promise of marriage. This court on several occasions had adjourned the matter, awaiting the appearance of the second respondent. The second respondent remains, the counsel for the second respondent remains absent throughout. This court on 12/6/2024 had passed the following order. Even today, there is no representation on behalf of the second respondent. Therefore, the petitioner, counsel for the petitioner and the respondent state are heard. At this juncture, the learned counsel for the petitioner submits that the second respondent is already married, has already got married to another person on 1/5/2024. I have given my source. The aforenarrated facts are not in dispute. The accused number 1 and the petitioner meeting on a social platform, Instagram, is a matter of record. It happens on December the 9th, 2021. The relationship goes on several occasions, goes on for close to 3 years, close to 2 years. It is taken up to the stage of marriage talks between the complainant and family of the complainant and the family of the accused number 1. The betrothal ceremony takes place between the two.
12/5/2022, my lord.
On 12/5/2022. It is later, due to certain misunderstanding between the two families, the marriage does not take place. The marriage breaks. The breaking of the marriage leads to the complainant registering the complaint, dragging the petitioners 2 and 3, the parents of accused number 1, also into the web of crime. Since the entire issue has now sprung from the complaint, I deem it appropriate to notice the complaint, page 19 to 21. The complainant in the complaint narrates that on several occasions, on the score of promise of marriage, the accused number 1 has had physical relationship with the complainant, and therefore the consent of the complainant was taken on deceit that he would marry the complainant. The police, after investigation, filed a charge sheet. The summary of the charge sheet, as obtaining in column number 17, reads as follows, page 42. In between the registration of the crime and the filing of the charge sheet, the complainant herself tenders a statement under section 164, which becomes necessary to be noticed, page 78 to 80. If the complaint, the summary of the charge sheet, and the statement tendered by the complainant under section 164 of the CRPC are read in tandem, what would unmistakably emerge is that the consensual acts between the two did not remain consensual acts. It led to the talks of marriage. The marriage does not take place. Therefore, the allegation against the petitioner cannot be dubbed to be on the pretext of false promise of marriage. It is a promise of marriage having breached for reasons beyond the control of accused number 1 or the family of the complainant, as it is the parents of the complainant and the accused number 1 who did not cooperate for did not cooperate for the two to get married. This can by no means be said to be a false promise of marriage for the petitioner to be permitted to be tried for an offense of section 376 of the IPC. What remains is section 417 and 420 of the IPC. Cheating is alleged by the complainant on the score that the petitioner breached, for accused number 1, breached the promise of marriage, and accused 2 and 3 have cooperated in such breach. For the reasons so rendered to obliterate section 376, the offenses under section 417 and 420 would also get subsumed. In the light of the fact that they have got subsumed into the reasons so rendered for the offense under section 376, the offenses under section 417 and 420 also would not hold water. The remainder would also follow suit. In that, in light of the aforesaid reasons, if further proceedings are permitted to continue against these petitioners, it would on the face of it become an abuse of the process of the law and result in patent injustice. As also the law laid down by the apex court in the case of Naeem Ahmad versus so-and-so, reported in 2023 SEC Online SC page 89. Therefore, for the aforesaid reasons, allowed quashed by the petitioners.